this morning is no other person than our chairperson at the Forensic Society of Nigeria. She's the chairperson of Disciplinary and Ethics Committee. And she's no other person than Barrister Queen Oniwon. Barrister Queen Oniwon is the managing partner at Beth Kalp Legal Practitioners. Beth Kalp Legal Practitioners. And today she will be speaking directly to us on the theme of the conference of the workshop this morning. She would be talking to us on courtroom knowledge of forensic technology and its impact on the Evidence Act of 2011. Courtroom knowledge of technology and its impact on the Evidence Act 2011. Over to you, Barrister Queen Oniwon.
Hello, good morning. Good morning, everybody. Good morning. Please.
Good morning, ma'am.
Oh, can we all hear me?
Yes, we can hear you.
All right. May I proceed then if we can hear me?
Yes, we can hear you. Go ahead,
Yes,
ma'am.
Yes, go ahead.
Okay, good morning, and it's my pleasure to be here once more. I want to maintain the existing protocol that is already established. I am grateful for the opportunity to be in the society amongst very eminent people. Dr. Joan, CP Guazo, retired, Dr. Musa, the registrar, Emmanuel Olomu. I am beginning to say the protocol all over again, but let me still maintain the existing one that has been established. I am so grateful for the opportunity, and I want us to consider it as an exchange of knowledge. I will not be talking on every one of us because I know we are all vast in our various professions. Now, I go straight into the topic. I had mentioned earlier to our moderator that I have some issues with electricity here, and we are faced with the scarcity of fuel, so I can't bring some of my devices on, so I just have to make do with my phone for now. I'll make sure to share my slides and the other materials I have with everyone, and this is a promise I have to keep. Definitely. Let me just go straight to what they call by Section 6 of the Constitution of the Federal Republic of Nigeria, in all matters in criminal matters, and it goes on to that we have assigned powers. Section 29 already. We are forensic technology. When I say nothing, it's not as if we as pronounced as in other countries. So this morning I want to attempt to have to give us, just by way of introduction, what forensic technology is, an overview of the Nigerian Evidence Act. Then I'll talk briefly on what admissibility of forensic evidence will be in Nigerian courts, how it will look like. I'll mention briefly the challenges associated with using forensic technology and the impact of forensic technology on criminal investigation. I will also try to touch on what ethical considerations will be for someone who wants to use this means of tendering evidence in courts, and a few case studies. Like the last time I was in Chrisland, I just had to make use of very practical examples, and I know that sometimes we can relate with some of these things when we have one or two practical examples. I'll attempt to also do that. Please, can we hear me? Please, can we hear me?
Yes, we can hear you.
Okay. Established that the courts are vested with judicial powers to listen.
We can hear you. We can hear you, but it's fluctuating.
Okay. I already. That's why I switched you.
Okay.
I already mentioned that the courts are vested with all authority to hear matters, and then the courtroom in this context may not just be the four walls of a courtroom. It's not just the Federal High Court, the State High Courts, the Supreme Court, Court of Appeal, or even Sharia courts. It is anywhere so designated with judicial authority to hear matters. So it might be a tribunal, it might be a panel of inquiry, it might be, but once they have the power by law to hear matters, it becomes a court. It can even be an arbitration hearing where parties have agreed that they would sit together and resolve their matter and appoint for themselves arbitrators. So it's still the evidence received in such proceedings can be likened to a courtroom. So I want us to expand our mind, just not to restrict it to the courtroom. But for this context, I am looking at the court so designated under Section 6 of the Constitution, Federal Republic of Nigeria, 1999, as amended. And forensic evidence is critical in modern criminal justice system, not just in the criminal justice system, but also in civil matters. You know, there are times when people want to prove that they have better title to land and they want the court to be convinced, and they bring in documents from 1901, you know, and probably that document was procured under the bridge, pour some oil, have some Ancient of Days typewriter type on it, and they want the court to be convinced that this document has been existing since 1901. You know, so the duty of the forensic investigator in this context, even though it's not a criminal matter, might be to question that document and, you know, try to understand the age of that document by subjecting it to forensic analysis. So it's not just in criminal investigations where it is a matter of life and death. The decision of the courts, if relying on the opinion of the experts, can either lead to the person being exonerated and discharged and acquitted, or being convicted. So forensic technology is so pivotal, not just to the criminal justice system, but to the justice system as a whole. And we all know that it is a process of technologically advancing evidences, studying. It has to deal with recovery of sorry, there's an aircraft hovering around me, so it's interfering. Can we still hear me? Can we still hear me?
Yes,
we can hear you clearly, ma'am.
Okay.
We can hear the aircraft.
So the range of DNA profiling, ballistic analysis, it's fingerprint analysis, handwriting analysis, you know, blood sample testing, crime scene investigation. There's several steps to the forensic technology, and it's so vast. You know, every field of endeavor is using forensics. The accountants are trying to dig into records to know what is the real source of funds and all that. So it applies to the accountants, it applies to schools, it applies to the courtroom, it even applies to your home. You know, sometimes you want to be sure who took what or who said what, and as a parent you want to call your children to order and say, who did this, who did that? And then you are not God. You begin to question, you begin to say, this handwriting is the handwriting of Ade, not the handwriting of Shade, you know. So it's so applicable to us, it's so with us. So I go on to the next part of it, which is the Evidence Act, the Nigerian Evidence Act 2001. I'm looking at courtroom use of forensic technology and its impact on the Evidence Act. The Evidence Act is the law that guides how evidence is received in Nigerian courts. Before now, the Evidence Act had 1945 stayed with us more than over almost half a century before we could change it in 2011. And what that Evidence Act did was to close its eyes on several ways on which evidence would have been presented to the court. So it allowed so many people to go away with things that they should have been convicted with, because there was no law to present such evidence in courts. It did not allow forensic evidence to flourish in Nigeria. So it was I want to mention someone who is dear to us in Nigeria, and whom we are just realizing that he was good. Of course, that's subjective. Dr. Goodluck Ebele Jonathan was the one that signed in the Evidence Act 2011 by Section 84 of that Evidence Act, Section 68 sub 1 and Section 68 sub 2, Section 101 of that Act, Evidence Act 2011. It made it forensic evidence applicable in Nigerian courts, and it also allowed that procedures to be laid down for us to present electronic evidence, for which forensic evidence falls under it. So amongst many other things, that's Evidence Act of 2011, which was also amended last year to allow for electronic signature and some other innovations, is now even obsolete, because there are some things that are coming up that Evidence Act has not taken care of, and we hope that it will continue to be revolutionized. We continue to move with the times. So I want to also mention that for us to be able to use evidence generated from forensic technology, and in fact any other evidence in the courtroom, the evidence has to be relevant to the facts in issue. If it's a fact, you know what a fact is. A fact is that you have admitted that something exists, or proof that it does not exist. So many people swear on oath and eyes. So because we are not angels to discern or decode that this person is lying, or we don't have lying machines to detect whether they are lying or not, we have to be able to understand whether that statement or facts they are presenting in court is relevant to the case in question, whether it is reliable, whether the court relying on these pieces of evidence can convict somebody or exonerate someone, you know. And then it has to be compliant with procedure. So it has to be for it to be admissible, it has to be relevant, it has to be reliable, it has to comply with procedure. It has to be tendered by an expert. The court is not swayed by general opinion of the public. Let me give an example vividly here. Last year or 2 years ago, we all woke up to that outcry by a child that was bullied in a particular school in Lagos, and the child passed on. And then everybody were just crying wolf. This school must be closed down. They were protesting that school. And listening to the news recently, in fact, they even got a senior advocate of Nigeria to represent the family of the deceased child, But at the end of the conclusion of the matter in the coroner's court, a coroner's court is a court that determines, that listens to evidence to determine the cause of death in a place. Now, in that case, that it was even the parents and the hospital that was negligent in handling the child. So if there is anybody that should be charged for criminal negligence and brought to book, we are going to start looking for the parents and the hospital that handled the child. So that's to tell you that it is not by public opinion. The court is not moved by sentiments, but by facts. And these facts that are presented in a manner that has been laid down by law and procedure. So law of evidence is generally a law that is procedural in nature. You have to apply strictly to procedures. And that being said, the degree to which you can convince the courts to be swayed to make decisions in line of the evidence presented to the courts will depend on whether it is a criminal matter or a civil matter, whether or not the evidence you are bringing supersedes what has been presented by the counter opponent, your adversary in court. Let me break this down. We know in civil matters, that's for people who have a bit of who are not lawyers. I want to just bring it down. I'm not saying everybody will be a lawyer, and I hope that everybody should be one. Okay, now the degree of evidence to be received and for a court to rely upon it in a criminal matter, it should be a piece of evidence that is proved beyond reasonable doubt. So in the eye of the right-thinking member of the society, this thing is so factual that you cannot but rely on it. And also, in criminal matters, there is, especially in capital matters, there's matters that require that the persons can be put to death. We're still praying that probably one day in Nigeria will turn death sentencing, but as it is now, death sentence is with us in our country. So for you to say a judge should rely on a piece of evidence to give a verdict of death or hand a sentence of death to a particular accused person, you should be able to prove beyond reasonable doubt. And that's for a criminal matter. And the degree of doubt, the degree of proof should be at least, there should be no margin of error. Like scientists will say, the margin of error should be 0.00. So if there is any reason for the court to have doubts as to the evidence presented to the court will resolve in favor of the accused person. And this has just been the position of the law. But then if we in a civil matter where it's not that somebody's life is at stake, the preponderance of evidence will be what will be relied upon. So it depends on who can win an argument, who can present a better argument or a superior argument. So that being said, I want us to go on to I've said that for a piece of evidence to be received in court, it has to be admissible, it has to be relevant, it has to be reliable, it has to comply with procedure, it has to be presented in a manner according to law. Now, let me look at some of the challenges that present itself in our Nigerian courts. Some of the challenges that a forensic expert will likely face. When you are bringing in pieces of evidence in the courts, our courts in Nigeria are not like the courts we see on television. You can start a criminal trial, except it is the one that is bound by time, probably a tribunal, as we saw in the election petition tribunal, that they are time bound, that within this period they must finish, within 180 days they must conclude everything. But it's not the same in Nigeria, in other courts. There are other matters contending for the attention of the judges. So a criminal matter can go on for years before it is finally concluded. I don't know how it is in other states in Nigeria, but I know in Lagos State it is a different ball game. It's just how you imagine the traffic on the roads. That's how our courts are congested. I'm sure it's not like that in other parts of the state, but the speed of trial is relatively slow. But that being said, the wheels of the judiciary grind slowly, but it grinds surely, and justice rushed can be justice crushed. But then the defendants will say justice delayed is justice denied. But that being said, I know that that's a big challenge, a huge challenge for us. Then we have technical complexity. Most states do not have a laboratory to test evidences forensically. Most courts do not have it. We have resource constraints, like every other thing in Nigeria. There's so many needs battling for limited resources. Then the role of the expert that is giving the testimony is also another challenge. Some people subsume themselves into the trial. It looks like they've taken a position and they just wish that this position must be maintained. Let me give an example. In a case, I don't like throwing cases, but let me just say this. There's a case of Harrison versus Odiawa. Harrison Odiawa versus Federal Republic of Nigeria. The person impersonated was charged for impersonating under the Advanced Fee Fraud Act. That's what we regularly call 419, for impersonating the one Abu Belgore, and he defrauded a foreigner. And the foreigner, noticing that he has been defrauded, petitioned the EFCC, and the EFCC swung into action and picked so many pieces of evidence from his office, his documents that bear his handwriting and all that, and they subjected this to forensic investigation. And they saw that it tallied with some of his handwriting and was convicted. But upon appeal, he also presented another analysis from the force headquarters, saying that those were not that the evidence collected from him does not tally with his usual handwriting. So there were two expert opinions that were conflicting, and the court decided that his own defense was out to prove a point. He was out to say that this person is innocent, ab initio, so they couldn't rely on him, apart from the fact that he couldn't establish that he was an expert. So sometimes some people just throw themselves, you are a woman and now you are an investigator, and you are a prosecutor, and you have called in this forensic expert, and you just hate rape. And notwithstanding that this person did not commit the rape, you just want the person to be guilty by force, So instead of prosecuting, you're already persecuting. So some experts can get to that level. And I also want to mention, with all sense of gravity, because it is still something we are investigating. We just found out that in a course of prison visits, I mentioned this as a privileged information. I am very involved in the human rights activities in my branch, and we had to be at the correctional facility, and then we met this young man who said his lawyer actually asked because the evidence of the experts against him showed that he actually defiled a young girl. I'm like, did you actually do it? He said he didn't do it. And I'm like, okay, is your word against this? But that piece of evidence should have been tried. It should have been tested. But he said his lawyer told him to do that so that he can have a lighter sentence. But unfortunately for him, he was given maximum sentence, like the person who defaced the Naira recently. So that is why it's so important that this challenge of the personality of the expert, the person presenting it, and even what he's presenting should be without bias as much as possible, should be neutral, should be professional. I also say it because we found out that a particular report emanating from a particular organization is so generic. Once that report goes there, for them to confirm whether a girl has been raped or defiled by the defendants, it comes out 100% of the times that the person is guilty. Do you get what I'm trying? They just established that, oh, this girl has been raped. It's so generic. So I think we are beginning to say, oh, let's look at these things and question. Of course, the knowledge of forensic will help us to question such things. So those are some of the challenges. I move on from that to also looking at qualification. Some people are not really qualified. Nigeria, with the way we do things, anybody can wake up and be an expert. Everybody's shouting on social media. So there isn't a way to streamline who a forensic expert will be. And in this case, we know that it is not an educational person, somebody who is educated that is an expert, but somebody who understands and have an experience in what he's doing. He has requisite training, and he has to be certified, or somehow he has to be an authority to be able to be entertained by the court. And then another issue, another challenge to forensic investigation is cross-examination. Experts who wants to present testimonies in court will face serious cross-examination. Recently we woke up to the death of a TV superstar, a TV owner, murdered by his girlfriend in Lagos. I know if I mention the names, you would understand who I'm talking about. And it was all over the news. And the girl was a student of Unilag. She confessed. Police said she did this. They saw the phone of the deceased in the sister's hand. And it's it was all over the news. The media hype was so big, and everybody already condemned the young lady. But shortly after, while in prison, in the correctional facility as an awaiting trial inmate, the young lady contested in a beauty pageant and she emerged Miss Cell. And the public outcry. They were just, everybody on the social media was raving, like, how can they like this kind of method of judicial criminal justice system we have in Nigeria that permits all sorts. And there were so many issues, but she's still an awaiting trial inmate, and until she's convicted, she's innocent, until it is proved otherwise. And at some point, the young lady even changed her testimony, and people were like, oh, she has consulted lawyers and their antics, they have tutored her on what to say. But recently, very, very recently, it's in the news again that they have received forensic evidence linking the dress she wore, with the victim's blood. So the victim, that's the person purported to be killed, her blood the blood of that victim was found in the red dress she was wearing on that day. So the doctor, now I think his name is Dr. Somari. I'm already mentioning names. Somiari a forensic expert, he said he has 15 years of expertise and all that, presented this evidence in court, and the court has admitted the evidence, So, but the point I'm making is the point of cross-examination. You would think that, this person, being a forensic expert, being at what he's doing for 15 years and more, and handle several cases, will just go without any cross-examination. But the defense lawyer subjected him to rigorous cross-examination. He requested that the crime scene should be played in court, and the court obliged him. And he was asking the forensic expert, apart from this girl's dress, did you check the curtains? Did you check the walls? Did you receive? The man said it is what was given to him that he received, and he worked upon with his staff. I wouldn't know what the decision of the court will be as it progresses. We would hear the verdict. But I am particular, for the purpose of this paper, I'm particular that forensic evidence is being received in criminal proceedings in Nigeria, and that forensic experts will not escape cross-examination, no matter how well versed they are in their field of expertise. So the lawyers are prepared to demolish the expert's opinion that has been received, and convince the court that what they are saying cannot be relied upon. So that's a challenge for the forensic expert. So it's not enough for you to gather the evidences and say you are going to court. The defense lawyer, if he has been hired and paid well, will do his job. But that being said, admissibility is one thing. Whether the court will attach weight to what has been admitted is another issue. I'm trying to race against time, so I'm talking very fast. Please, can we hear me?
Yes, we can.
Please,
yes,
can we hear
you? We can hear you.
Okay.
Yeah.
All right, so that we'll be on the same page. So I am on the fact that whether or not the court will attach weight to the pieces of evidence received is another issue. The courts and judges are allowed by law to dispense their justice judicially and judiciously. So some of those things that are not expressly codified by law can be left to the discretion of the court. So, for instance, let me bring this home. Somebody comes before the judge and they played a particular video where the person was throwing Nigerian naira notes on the floor, and then the prosecution says, you are the one in this video throwing down these naira notes, and the person said, yes, he's the one. I guess he's trying to say, okay, he will now work on the judge's discretion to say, okay, he should just receive a fine instead of maximum sentence of 6 months. But the judge exercised her discretion to give sentences judicially and judiciously, and he received 6 months sentence. So what am I trying to say now? Another person had the similar charge. We don't know how that goes now, and they bring him before a judge, and he said he's not guilty, and the law is that he should be admitted to bail, and he was admitted to bail, and he's back at home posting on social media, and everybody will be like, the judges are not fair, they are not this, they are partial. No, judges act according to law, and this law expressly are codified. They are acts of legislation, but there are still some aspects that are left for their discretion. That's the point I'm making. So the aspect of attaching weight to pieces of evidence is completely in the discretion of the court. Let me bring another vivid example. Many of us were hoping that the Beavers was a game changer, a life changer. In fact, when some of my illiterate relatives, of course I'm a villager, let me just admit. So I'm not the only, we are not all educated in my village. Some were asking me, what is this beavers all around, all about? What is beavers? I say it's like the way you deposit money in the bank, and the bank will now show you that alert that see, oh, they have deposited money in your bank. And so they understood it as simply as I put it. But I didn't know that it would not be that simplistic. Of course, when the judgment of the election petition tribunal was being read, we all seated, they were trying to ask me, what is this one saying? At some point, some people were dozing, And then the conclusion of the court is that the INEC is not mandated, is not compelled to transmit results using the beavers. So it's the discretion of the court, And so INEC can decide, okay, we are not using alerts like I in a layman language that I explained it. We are now using sheets of paper, and everybody will now sign on that sheet of paper. So it's that sheet of paper that we are now relying upon. I hope our laws will change pertaining to election. We still pray for Nigeria. So, but for the purpose of this paper, I am just saying that the discretion of the court matters in the evidences before the court. The weight to attach to the evidence matters. So somebody can say, I have this, I have that. If the court is not looking at it, it's just what it is. It is not an evidence to be relied upon. So one other challenge I look at is privacy, consent, and the lack of, I've said the lack of capacity, then privacy and consent. Some people know very well and understand that the law in Nigeria protects your privacy. It's a fundamental right. So sometimes you can't invade people's privacy to take what you need. Of course, no matter how you go to procure your evidence, once it is true, the court is bound to rely upon that evidence. But the challenge is, how do you get a true evidence? How do you invade? Sometimes some law enforcement agents have been reprimanded for breaking into people's hotel room to go and arrest them or try to seize their laptop, seize their phone, and there have been a public outcry. Of course, in the process of doing that, if what they get as evidence can incriminate a criminal, it will not matter how they collected the evidence. I also want to mention here too that another challenge that the experts will face is actually some provisions of the law. Now, most courts will look at the fact that an accused person have a right of silence. He has a right of fair hearing, which is guaranteed under the Constitution, Section 36 of the Constitution, Section 35 of the Constitution. If these are constitutional safeguards, if the expert is not taking precautions to protect the constitutional rights of the accused person and he violates that, it can turn around that his evidence will not be relied upon. I try to give an example here. Sometimes my due respect to the our law enforcement agents who are our friends, the police is our friends. Sometimes they don't go on to do more to investigate. So the investigation chain is just that somebody complains via petition, another person receives the petition, and based on the contents of that petition, the person mentioned in the petition is arrested. And then now when he's arrested, he's just made forced to write confessional statements, so that he will just tender the confessional statements for the court to rely upon. These have proved to be Herculean for some people, because now the administration of Criminal Justice Act, ACJA, mandates that for you to receive what's it called, statements from accused persons, he has to be in the presence of his lawyer. There has to be recordings. There have to be several things in place. So mere confessional statements is not just enough anymore. Also, the Cybercrime Act also provides that forensic evidence can be extracted from phones, from laptops, and all that. So we should look into these laws so that we stop just doing confessional statement, just on your table, everything has ended. We do respect to the police. The police are doing a lot, but there needs to be more to be done in this area. I hurry on to look at the fact that once our evidence is obtained and it is correct and it is procedural, it is possible for us to secure either conviction or acquittal for our either our clients as lawyers or our our accused person as prosecutor. Please, can we hear me?
Yes.
Please,
Yes, we can hear you. Yes, we can
Can hear you clearly.
I quickly
Yes, we can hear you.
run to the case of one Richard. No, let me just get this fact well. Okay, a senior advocate of Nigeria, Dr. Joseph Nwobike, was arrested and charged for giving gratification to public officers, and then the EFCC also charged him for making false claims and giving false evidence to them. So what happened was that this man was trying to bribe some of our incorruptible judges to sway them in his favor on behalf of his client. Apart from the fact that it's a criminal thing, it is also highly unethical for someone of his status, a senior advocate. So what happened was that the security agency swooped on him and seized his phones, and then from his phones were subjected to several analysis, discoveries, and a WhatsApp message to a court official was extracted. And in that WhatsApp message, he had sent some monies to this court official, and he had explained to him how he will share it to certain judges. So on the strength of that information, on strength of that piece of evidence, the court convicted him. The Lagos High Court convicted him. He was sentenced to 1 month imprisonment, and of course some other thing. And even on the strength of forensic analysis and investigation, there was another case, several cases where people who had gone on appeal were discharged and acquitted. There was a case of a case that was dispensed in Ondo State High Court, a case of Feishayo Alatishi and the state. The trial court said they were guilty, that they linked the gun recovered at the scene of crime to them. But on appeal, the judge concluded that there was no link, that there was no forensic evidence that the trigger that killed the victim was pulled by the convicts. So the court overturned their 14 years sentence for conspiracy and the death sentence for culpable homicide, or murder, because it's Ondo State. So what I'm trying to say is that once we develop forensic technology and we gather evidence ethically, and the chain of disseminating these evidences are not contaminated, we are hopeful that the court can receive it and attach a weight to consider it in their judgment. So I want to conclude by saying that there's a lot more we can do. Heads of courts and decision makers, policy makers, can begin to look at our criminal justice system with another eye, with another lens. is there anything wrong for a court to have its own forensic investigators? Is there anything wrong for a magistrate to even be well trained in forensic analysis? It's not for him to descend into the arena and say you are guilty or not, but for him to be able to have an objective perspective of the evidences before him. So he will not be in the dark. You know, somebody will not come and hoodwink him because he's a lawyer or because he's a prosecutor. So that being said, I am advocating that we need, as a matter of urgency, to begin to enact policies that will make forensic technology applicable in all courts. I mean all courts. Of course, the Evidence Act 2011 is not the act relied upon in some courts. Some courts are exempted from using the Evidence Act, customary courts, Sharia courts, you know. But what I'm trying to say is that if the Evidence Act 2011 is the prevalent law that is stated for us to rely on to bring our evidences, trials before the courts, are we not going to look at ways in which we can make our opinions count, especially going by Section 68 of that Evidence Act? So that being said, I want us to go back. I know I'm speaking to people who can influence policies. I'm speaking to people who are very eminent personalities. We can begin to ask that our laboratories, our forensic laboratories, be well equipped. We can begin to ask that our experts that we train, that's our IPOs, our first responders should get a bit of forensic knowledge, technology knowledge, in addition to their qualification. So that's my humble submission. Thank you. Thank you for listening.
Wow, thank you so much, Barrister Queen Oniwon. For those that joined the debate, that was Barrister Queen Oniwon's presentation. Barrister Queen Oniwon is the managing partner at Beth Up Legal Practitioners and presented on courtroom knowledge of forensic technology and its impact on Evidence Act of 2011. I don't know if we are taking notes. I have my notes here and I've learned a lot that I can't even start talking about. I now understand the Evidence Act. I have a better understanding of the Evidence Act and that it was signed by Goodluck Jonathan and what it entails and all that. And I've learned a lot this morning and I hope we are taking notes as well. Thank you so much, Barrister Queen. I hope you still have enough electricity on enough power on your device to answer questions.
Band C or Z. I don't know the band.
Okay. All right. I think it will be wise for me to take questions then. So I think I should just open the floor for us to ask questions. So do we have questions for the presenter, for Barrister Oniwon, before she runs out of
Yes, I have questions.
Device?
I have questions.
Our presentation.
Yes, I have questions.
Something struck me, Barrister. You said court is not
Are you hearing me?
Public opinion. Oh, okay. Yes, sir. We can hear you.
Yeah, I said that. Yeah, okay. My question is, I want to thank Queen Oniwon for the beautiful presentation. And then he has actually dealt with a lot of things concerning the expert witness. And then she did mention that the court should have an expert witness. In the area of cross-examination, it is the expert witness in the court that will be able to cross-examine using technical terms. For instance, if an expert witness is presenting an evidence in the court. The process of obtaining that, the process followed in obtaining that evidence, there are some technicalities that need to be applied. And that is the more reason why an expert witness in the court would be the better position to cross-examine. Take, for instance, if the tools used were licensed and the type of tools used, are you certified to use them in this process to make it relevant in the case at hand? So I think I've been directly answered my own question. The question I wanted to ask was that the lawyer who is examining an expert witness might not be technically grounded. Hello, are you hearing me?
Hello, Mr. Richard.
Are you hearing me?
You are breaking off. I'm not sure if it's from my end.
Okay. You can hear me. Okay. Yes. What I'm trying to say is that it's more or less like my own observation that the better person to cross-examine an expert witness is an expert witness. I mean, it will be an expert witness.
Is an expert himself.
Okay. Exactly. So because of the technicalities involved in obtaining the evidence, it needs to follow the normal rule. Thank you very much.
Please, may I respond to that? Or do I have all the questions together and I respond?
Yes, please.
Okay, if I may understand your question.
I think you should respond to this.
If I understand your concerns, that usually the experts of forensic expert tenders his evidence in court, but the cross-examination should be by another expert. So that's the essence of this capacity building. I was wishing that every lawyer would be here. You know, I just mentioned that the coroner's inquest into that popular case, the defendants, the witness, now the complainant hired the senior advocate, you know. So I'm not saying the senior advocate did not do his job or did his job well. There are some tools. Now, if my duty as a defense counsel does not smell the four walls of a correctional center, I will do everything within my bit to demolish the evidence of the expert. But if I am a prosecutor and I need this person to be convicted and to be brought to book, I will do everything within my bit to make sure that this person does not have a leeway. Do you get the point I'm trying to make? That's why forensic knowledge and technology is important to every actor in the courtroom. Now, it is more important for these two actors, that's the defense, the prosecution, the accused person, or depending on what your role is. But it's even more important for the judge, because the judge is supposed to receive all these evidences, weigh them, see whether it is ethically collected, see whether it is judicially, whether it's relevant, whether it complies with law, whether he can, it's enough for him to rely upon it to either discharge or convict the person. So who really needs this forensic technology knowledge? It is the judge. And it is so sad. I want to say this with all sense of responsibility, that the process of appointing judges in Nigeria still needs to go through a lot of scrutiny. It still needs to go through a lot of rigorous exercise. You know, I think in Nigeria, the hardest job in Nigeria has the lowest qualification. I beg to say. By all means, judges are qualified. They go through rigorous years of legal training and so many other factors, political and otherwise, are considered before judges are appointed, because they have the power of life and death. I think the measures to appoint them should be more stringent, and we should even include forensic technology knowledge to what a judge would need to qualify as a judge. I'm just saying this as my own opinion. You know, for instance, now there was a case somebody mentioned. They brought the judge was, let me say, analog in thinking. He still felt that for somebody to receive a letter, you need to go to the post office, affix a stamp, and then post it to the person that you want. You know, those days of pen pal, those days of receiving letters from London and all that, the postman drops it at your doorstep. So the EFCC arrested this young man for being in possession of mails to defraud, and that one of those things they presented were the mails that he has forwarded to the persons he defrauded. And you know, when the judge was receiving the evidence, he was really confused. At the end of the day, I think he didn't consult properly. He didn't ask for expert opinion and all that. He said, to his mind, if the mails have been forwarded, how can the accused person still be in possession of that mail? Has he not posted it? And he discharged and acquitted the young man. But you know that in a court that the judge sitting there is well advanced and knows what is current and obtains in our contemporary world, that young man will not go scot-free. So please, have I answered your question? It depends on where you are acting, whether you are the judge or you are the prosecutor or you are the defense. Everybody needs this in the courtroom.
Definitely.
I know Nigeria, I hope we move on forward as fast as we can. Even the office of the president as it stands in Nigeria now, somebody who didn't even pass WAEC can be our president, and it's just fine, you know. So I'm sure that so many states are reviewing their process of appointment of judges, and so many things are coming into play.
Yeah, thank you very much.